We focused on two types of cases. We focused on cases which had been finalized before either a court or an administrative tribunal. And then we focused on what we call live cases or pending cases where the challenge to the granting of the prospecting or mining right was still in process. These typically involved a number of processes which overlapped. So in some cases they could have been finalized and in other cases still carrying on. For the finalized cases, we looked at all the available legal databases, which include JUTA's database of reported cases and unreported cases, and the same for LexisNexis. And LexisNexis in particular goes back to the 1890s. So we've tried to look at cases dealing with, particularly with mining and the environment. There had to be a mining component in the case, not just an environmental case that was applicable to mining. However, we have identified cases that are possibly applicable. We have a separate list of cases that were excluded and the reasons for them being excluded. So together we have 32 finalized cases, and then we studied 17 live or pending cases. I think I'm going to identify two main things. The first is that in one sense, the more things change, the more they stay the same. If you look at cases from the 1890s dealing with issues around water coming onto the claims and the kinds of struggles that ensued between the mining operators and then the statutory boards at that time who had a kind of regulatory role, and the kinds of issues we're now facing with acid mine drainage, for instance, and the cluster of cases that ensued in 2002 around pumping of acid mine drainage in the Kosh Basin. We had 3 cases from that time: the Harmony case, the Stilfontein case, and the Keppel case. It seems like we're still grappling with some of the same issues. We haven't really resolved liability for environmental damage. So that was one thing. But the second, probably more important thing that struck me was the gaps. We only have one reported case related particularly to mining environment in terms of the National Environmental Management Act. We have no case that constitutes a judicial review of the granting of a mining or prospecting right. For the Water Tribunal, we have no case that actually reviews the functioning of the Water Tribunal and the kinds of procedural blocks they've set up to adjudicating water disputes. And for the Constitution, we don't really have a case that talks about cooperative governance between government departments within a sphere. So those are significant gaps, and I think those are areas we could focus on in future. The most significant case in terms of the Constitution is undoubtedly the 2 Maxsand decisions, the Western Cape High Court and recently the Supreme Court of Appeal, which make it clear beyond reasonable doubt, I think, that the National Department of Mineral Resources cannot override the constitutional responsibilities and mandate of local authorities to determine land uses in their own areas. Other than that, we have one decision really that says that contempt of court proceedings can be used to enforce Section 24 obligations. The cases that relate to the interpretation of the MPRDA are entirely based on procedural issues or issues around public participation. The gem really is the Gwenyama decision by the Constitutional Court. And then we have a number of others. We have Mipo versus Kotza and Joubert versus Miranda, which also deal with the nature of consultation and access to land where there has not been sufficient consultation. For the National Water Act, there are really 3 strands. The first relates to Section 19 of the National Water Act, which has to do with a duty of care in relation to pollution of water resources. So the premise that we have there is that Section 19 does have extraterritorial application, or it applies beyond the mining area. So the duties of the mining company extend beyond the mining area on which they operate. The second relates to the clarity of directives required in terms of Section 19.3 to hold someone liable on the basis basis of contempt of court. And that was the Kibble case. And then the third set of cases is really around the Water Tribunal and this problematic issue of locus standi before the Water Tribunal being linked to the regulator actually calling for public participation. I think the three cases stand out for me. The first was the case of Rex versus Marshall, which was a criminal case decided in the 1950s on a mining company's failure to implement their obligations to treat acid mine drainage before it left their mining area. So that shows that not only were there regulations enforced that regulated AMD, they placed the responsibility on mining owners to render their water innocuous before it left their property, but that it was enforced. And this case is a wonderful case for showing how the court just dismissed with these kinds of procedural, technical, hypothetical, speculative arguments put forward by the defense and really just got to the nitty-gritty of the matter. I think it's an outstanding case. The second is the case of Richtersveld Community versus Alexkor, which was a case decided in the Land Claims Court. And an interesting precedent there which says that the Land Claims Court has competence when they make an order for land restitution or equitable redress to make an order compelling the respondent to either compensate a community for environmental damage or to repair that damage. So I think that's probably an underused capacity of the Land Claims Court. And then the third is a case dealing with a common law duty. It was decided in terms of the Minerals Act, but I think it still has application and we can explore it, is the case of Anglo versus Sandhurst Estates. And the duty there is the duty of lateral support, which relates to both land use adjacent to a property and land use underlying the property. And the case itself was concerned with surface mining. And the precedent there is that an owner cannot relinquish his right to lateral support without his consensus. And that flies in the face of the fact that mining can take place without the consensus of the landowner in terms of the MPRDA. The Bengwenyama case is an absolute gem for civil society, I believe. 5 issues were decided really in that case. The first was that the Constitutional Court clearly established that Section 96 of the MPRDA does provide for an internal remedy. There was some uncertainty about that given the case law prior to Bengwenyama. Secondly, given the DMR's tendency not to respond to or to take a very long time to finalize these appeals, the Constitutional Court considered when the internal remedy is regarded as concluded, for purposes of bringing a review in terms of the Promotion of Administrative Justice Act. In terms of that act, you've got to bring it within 6 months after the appeal is concluded. So what the court held in this case was that it's concluded when the DMR responds to you. Thirdly, and this is probably the most important aspect of the case, the court laid down its view on what constitutes proper consultation with landowners and interested affected parties. It emphasized that there is a need for these parties to you have to be informed, first of all. Secondly, you have to be informed in sufficient detail. And this goes to the problem of landowners, occupiers, and other interested and affected parties not having the information before them, even though that information is available. It's available when an application is submitted to the department. And thirdly, that the nature of the consultation must be done, it must be done with a view to reaching agreements to the satisfaction of both parties on the impact of the mining operation. So this points to a substantive good faith requirement that if you look at some of the live cases is clearly not being met. Fourthly, again very importantly, the court said that communities' rights to mining on their land, this is section 104, talks about preferent rights. Where such rights can potentially vest in a community, the department must hold a hearing. This differs to other forms of public participation. A hearing is mandatory. And then finally, the Constitutional Court established clearly that consideration of the environmental requirements is a jurisdictional fact to the granting of a mining or prospecting right, which means it must be considered at the time that the prospecting or mining right is granted. Confusion arises because of the way that the MPRDA talks about the separation between the granting of the mining right and the approval of the EMP. And this, the DMR has its own internal administrative procedure to do this. In fact, they do consider the environmental impact, but the manner in which they do it, the kind of information that is before the decision maker, is not clear. So I think the Bengwenyama case didn't say what kind of detail has to be before the decision maker, but that is definitely something we can pursue and possibly challenge. The review of the pending cases enabled us to identify which issues were systemic, which issues applied across a number of cases. And in many ways, these issues were not surprising. We've known about them for a long time. The value of the review is that these deficiencies are now documented with reference to documents for each case, and we can talk about, how they apply across a number of cases. So kinds of the issues top issues that were systemic issues were the procedural and substantive inadequacy of procedures around public participation. Some outstanding examples of Mapungubwe case, the only substantive change between the EMP that was first put forward to interested and affected parties and the finalized one was one small change to the distance from Mapungubwe National Park. In the case involving Exxaro and on the farm Zukup, the public participation meeting was held on the 4th of August and the EMP was finalized for their case on the 6th of August, which points to the fact that the comments of those parties were probably not really taken into account. The second is of mining in sensitive and protected areas and different kinds of protected areas, not just private nature reserves, but also national parks in terms of the Marine Living Resources Act. And third is the extent to which inputs and work of other departments doesn't really make a difference, although the MPRDA requires the minister, she must consider these submissions when she makes a decision to grant a prospecting or mining right. I did not find in one case where it actually made any difference, even though submissions were submitted, even though they were submitted in very strong terms. Thirdly, the integrity of the environmental management programs, the scientific studies, especially not so much in terms of the identification of the impacts, but assessing the significance of those impacts. The failure to consider land claims when these are pending. And then what was a surprising finding was the extent to which the regulator used its own errors or shortcomings to dismiss appeals from civil society. And the most outstanding case in that regard is the Mine Waste Solutions Act, where the regulator had wrongly cited the property in the environmental authorization. The civil society submitted an appeal based on the correct identification of the property, and the appeal was dismissed on the basis that the property was wrongly identified. Meanwhile, an amendment process was already in place to amend the description of the property. So this is just completely outrageous. The other thing that sort of struck me about the pending cases was that you may be successful, but you're not successful. That even in those cases where there has been some measure of success, and I think of the Zolobeni case, where the appeal against the granting of a mining right for titanium containing sands was upheld by the minister. That appeal has not really resulted in the withdrawal of the mining license. It's simply allowing the mining company to respond to some of the concerns. So it does raise issues around the strategy of engaging on the case-by-case basis. Your victories are qualified. Okay, I think I've got my recommendations I've got 3 of them. The first I think is that every civil society organization should go and study the Bengwenyama decision and really start using it in objections and in appeals submitted to the minister, and possibly even in cases where the mining right has already been finalized. I think that the recommendations of the Constitutional Court are really clear. And it's great that we have that from the Constitutional Court. And also the Maxent decisions, and looking at ensuring that the mining company and the DMR make sure that permission from the local authority has been obtained. This appears not to have been a practice. For instance, when the DMR does its consultations with other state departments, to date they have not consulted with local authorities. So that's something that we should watch carefully, and we could possibly challenge decisions on the basis that the local authority has not been consulted, or they disagree with the land use in a particular area. The second recommendation relates to unexplored areas. I think that this common law right of lateral support is worthy of exploration. Although the MPRDA says that it overrides common law, I've seen mining rights where it states that the right is subject to the common law. So it's interesting, and also in that case, the court remarked obiter that if you had to relinquish your right of lateral support without your consent, this could run contrary to Section 25 of the Constitution, which protects the right to property. So I think that's an interesting thing to explore. The second is that we need a judicial review of a prospecting or mining right, the actual granting of a prospecting or mining right, and not the processes that lead up to it. And possibly focus more on the mining right than the prospecting right. Then we can resolve some of these issues around the time period for consultation, the adequacy of the reports, the consultation with other departments. And the third is that we desperately need a judicial review of the functioning of the Water Tribunal in terms of its locus standi. And then my third recommendation is looking at what stage you initiate litigation. And two cases come to mind here. The first is the case of Exxaro versus it's a number of property owners in Mpumalanga. And the litigation was initiated against the granting of the prospecting rights. So what happened is the litigation has stretched for over a long period of time. And in August 2009 of this case, the mining company and the government actually withdrew. So it looked like a victory. But in the meantime, they had just been gearing themselves up to apply for a mining right, which is what has happened. So do you initiate litigation at the stage of prospecting, or rather wait? Because it would seem that because of the time delay involved in judicial processes, you can actually, you won't really win, because they will just simply apply for a mining right. And the second is the Mapungubwe case, where litigation has been initiated essentially to stop operations while the appeal is being considered. And then again, because of the nature of court processes stretching out over a long time, and what has happened is that some of those issues have become moot, for example, or possibly moot, the granting of a water license. So I think it's better. We need to use these processes, but we need to think of the value of the precedent that we're going to get, and which stage to do it. And I would say we need to wait for that most critical stage of when a mining right is actually being considered. Access to information is definitely a burning issue. I would see it as part of the inadequacy of the public participation processes. There is a perception that scoping reports or the mining and work program, which is submitted as part of the mining application, which initiates everything, the EMP, that these documents are private documents. There's nothing in the MPRDA that says that they're private documents. In practice, they seem to often be withheld, sometimes in a misleading fashion. For instance, I have seen cases where a request has been made to view the scoping reports at a public meeting, and the consultants have said it is not available, whereas I could see from the documentation that the scoping report was available months before. So it's possibly a strategy that's being used to disable civil society, but in terms of the precedent that we now have from Ben Minyama, it's clearly unfair, and it would now be in the interest of mining companies and the government to make sure that these documents are available, that are transparent, accessible to anyone who may be affected by the operation or interested in the operation.